Tort or torts? Now, what is this? You might be thinking, is this a question? Yes, it is a very important question. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Law of Torts, now that we have reached a very important place where we are going to understand whether it is Law of Tort or Law of Torts. And how are we understanding? We are understanding this concept with the help of four very important videos, and in that series this is my first video. Here I am going to explain you guys how exactly we are going to attempt this question. What is Law of Tort? What is Law of Torts? All of that I am going to explain. Along with that, I am also going to explain that how exactly we are going to approach this particular question in my four videos. Not taking much of your time, let's get into the first slide. Whether it is Law of Tort or Law of Torts, you might be thinking that is this even a question? But once after you go through this entire session, you will understand how serious question is this. To start the discussion, imagine there is one Mr. X against whom a particular civil wrong has happened. Now he is coming to court A and convinces the court that he has experienced a civil wrong. So he is the aggrieved party. Court A says, yes, you have experienced a civil wrong, so you will get compensation for the same. Imagine the same person is going to court B and he says he has experienced a particular civil wrong, and if the court asks him to define as to which tort has happened, whether it is negligence, whether it is assault or battery, whether it is defamation, slander, etc., whatever torts are already been defined, in which it falls, and if only X able to convince that the civil wrong has happened against him is falling under one of this, only then if B court considers that that is a particular tort happened against him, then that's a different scenario. That's what exactly we are going to understand. There were two groups. One group believed that all the civil wrong are tort. That is why it should be considered as Law of Tort. Whereas the other group said, no, it is not Law of Tort, it is Law of Torts. There are already defined torts are available, and the aggrieved party only when proves that the civil wrong happened against him is falling under one of such defined torts, then he will get compensation. Now that's the difference. Under Law of Tort, there can be civil wrong 1, civil wrong 2, civil wrong 5, civil wrong 10, civil wrong 20, civil wrong 100. There can be any number of tort. As far as them is concerned, every civil wrong is a tort. Whereas the people who said it is Law of Torts, they very clearly said that there are already defined torts available, just like I have already mentioned: negligence, assault, battery, defamation, slander, etc. They are the already defined torts, and if the aggrieved party can able to put whatever experience they have gone through is belonging to one of these defined torts, only then that will be considered as tort. So that's the other group has to say. Now that is the difference, and if we understood what is Law of Tort and what are Law of Torts, now that we'll go and understand who said what, or who gave Law of Tort theory and who gave Law of Torts theory. That's in my next slide. Here in this slide, let us structurize the discussion in more better way. So we have Law of Tort and we have Law of Torts. The Law of Tort is a wider theory because there is always chance for new tort. Like for example, we have strict liability, we have absolute liability. All of these are newly recognized tort. How did they come into place? Because the wider theory supports the new tort. They say the new tort are possibility of every day, and Law of Tort is an evolving law. That's why we can see and we have to agree that there can be new tort. Now who gave this theory? Sir Fredric Pollock has given this theory. That is why it is also known as Sir Fredric Pollock's theory, or sometimes we are also called this as Winfield's theory, because Winfield has supported Fredric Pollock's theory, or this is also known as theory of Law of Tort, or as I specially mentioned in the beginning itself, this is also known as wider theory because this allows the new tort into court. Whereas the second group said there are already defined torts available and the aggrieved party has to prove that the civil wrong happened against him or her is falling among one of the tort which is already available. Only then that will be considered as tort. That is why this theory is also known as narrower theory because the scope here is very less. And this theory is being given by Sir John Salmond. That is why this theory is also known as Sir John Salmond's theory, or this is theory of law of torts. And the person who has gone through the tort has to prove that such civil wrong is falling under one of the torts already available. This theory is famously known as the Pigeon Hole Theory. Sir John Salmond's theory is known as Pigeon Hole Theory, and we are going to understand what exactly is that concept. And as I already told, this doesn't allow too many new tort into court. That is why this is also known as narrower theory. I hope this part is very clear for you guys. Now we have certain amount of clarity as to whether it is law of tort or law of torts. But how are we going to approach this particular question? I said in the beginning that there will be 4 videos. This is a brief video where I wanted to explain you guys as to what is law of tort and what are law of torts and who gave this theory and the different names and who supported and what exactly we are going to learn in our future videos. I have given a glimpse, but in this slide let us try understand how exactly we are going to approach this subject. First, we are understanding each theory. In my next video, we are going to understand wider theory. There we will understand the different new torts came into our society. We will understand who supported and who were against that theory. We will also try understand a lot of case laws. Okay. In the third video, we will try understand what is the pigeonhole theory or Sir John Salmond's theory and who supported, who criticized, and what are the different case laws that we have to see when it comes to pigeonhole theory. And finally, it is very important for us to understand what happens in India, whether we said it is law of tort or we agreed that this is law of torts. What are our takes when it comes to this question, whether it is law of tort or law of torts? That we are going to understand in my 4th video, where we will see Indian context with the help of 2 very beautiful case laws, and that will give answer to all the questions related to tort or torts. I hope that makes it very clear, and with that hope I am handing over this presentation to Nishan.
Aha! Looks like somebody's having fun here. He's playing, they're singing, they're dancing, they're doing everything. But I have to conclude this video here. With that, I'm concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.